invoking trusts, and even referencing international declarations on indigenous rights. The judge, meanwhile, is trying to keep this hearing on track while staying patient and professional. What happens when someone blends legal arguments, philosophy, and personal beliefs in the courtroom? Let's break it down. T starts off pretty standard. The judge asks if Tariq wants another probable cause conference, PCC, or if he wants to move straight to the preliminary exam. Tariq jumps in asking for a jurisdiction hearing, personal and subject matter. But here's the first twist. Tariq claims the court and state have no authority because the charges involve a trust, and legislative laws cannot interfere with contracts.
So I'll adjourn the probable cause conference in this case, April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable
setting the date
so
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PCC, to a preliminary examination.
Just for the record, I put it on the record that I object, but under threat, duress, or coercion. Again,
your objection is noted.
Right, and under threat and duress and coercion, I'll be here.
Court does call the case, People versus Tariq Day.
Senior Assistant Prosecutor.
I am Tariq Tariq Day, the executor of the Tariq Tariq Day Living Trust and the registered owner of the Tariq Tariq Day Ex Relatione Kingdom Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the 3rd degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or a $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
The judge calmly responds, "Okay, put it in writing. I'll deal with it, but spoiler alert, you're wrong." Smooth, measured, and honestly the only way to deal with someone going on a jurisdiction tangent like this. Things escalate quickly when Tariq references religion, indigenous rights, and international declarations.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter, and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant, indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role.
How what?
how religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No,
so I do have
sir, what you're about to state is incorrect.
At this point, the judge has to cut through the philosophical fog and keep the case moving. He explains that regardless of personal beliefs, court rules, procedures, and statutory requirements still apply. And when it's clear Tariq doesn't fully grasp the legal process, the court orders a forensic competency evaluation. This is a huge moment. Some might think it's a punishment, but it isn't. It's a safeguard. The court needs to ensure Tariq understands the charges and can meaningfully participate in his defense.
Well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules.
Is there
You
a
are
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution as well as the court and the officers agree to take a
That's
competency.
not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this
Yes, sir.
because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion. Yes.
Pardon?
Under threat, duress, and coercion. Yes.
No. Not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
Tariq verbally agrees, but even that's under his threat and coercion phrasing, showing he's still wrapped up in his own framework. Honestly, you've got to admire Tariq's commitment to his beliefs, though it's like watching someone try to play chess while inventing their own pieces. The courtroom is calm chaos. The judge remains professional, Tariq remains confident, and the legal system continues grinding forward.
I say yes. I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Anything from the people?
Would the court ask the people to prepare the order for the competency?
Yes, please prepare the order for the competency if you would, sir.
And the address for,
The defendant,
I see on the complaint is 1410 Share Avenue, apartment 1 3.
is that your address, sir?
Excuse me? That is correct. All right.
All right, very good.
And so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry, can I get that date again, please, sir? I can put it in my calendar.
July 25th, you were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I
the
did.
court.
I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it, I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before?
Well, as I stated at the last hearing,
No, don't go through what you
additional week.
stated at the last hearing.
Well, you
You
asked,
knew that, no, you knew it was supposed to be filed before the day. And man, you're gonna
That's it.
figure out something. We're playing by my rules, not yours. So you know, do not say anything because you're gonna figure that out real soon.
It's part philosophy lecture, part legal drama, and part reality check. The hearing ends with a competency evaluation order, bond continued, and a clear signal. The court will follow procedure, not philosophy. The charges stand, and the legal process moves forward. Tariq's creativity in the courtroom might make for a fascinating story.
Do they have it?
I have not received a response yet.
Since I'm sending in for competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay, no problem.
Then came the turning point, the competency evaluation order. Now, this isn't a punishment, it's a safeguard. When a defendant shows they don't fully understand the proceedings or the consequences, the court is legally obligated to assess whether they're competent to stand trial. That evaluation isn't about sanity, it's about comprehension. Does the defendant understand the charges, and can they assist in their own defense? So when Judge Simpson ordered Tariq for a forensic evaluation, it was the right call. Not out of bias, but out of legal necessity. It ensures any future trial is fair, and that the defendant knows what's at stake. And here's where I want to ask you, what do you think? Should the court have given Tariq even more leeway, or was the judge right to draw the line when it became clear the arguments had no legal standing? Drop your thoughts in the comments, because this case opens up a much bigger question. At what point does personal belief collide with legal responsibility? We all want freedom, we all want autonomy, but when personal ideology steps into the courtroom, the balance between individual rights and societal order becomes razor thin. And in this case, that tension was on full display. By the end, Tariq still stood firm, calm, composed, and convinced he was right. But the reality remained unchanged. The court has jurisdiction, the charges are valid, and the process will move forward. This entire exchange shows us something powerful, that the justice system, despite its flaws, still bends toward procedure, not emotion. The judge didn't humiliate him, didn't mock him, didn't lose control. Instead, he applied the law with discipline, fairness, and patience. And that's something we don't talk about enough. So now I'll ask you again. Who do you think was in the right here? Was the judge too strict, or was he simply doing his job within?
But it doesn't override jurisdiction, rules of evidence, or statutory authority. Oh, what do you think? Should the judge have given Tariq more leeway to argue his beliefs, or was drawing the line the only option to keep the case on track? Thanks for watching this wild courtroom breakdown. Hit that subscribe button for more legal drama and real case breakdowns. Trust me, you don't want to miss what's next.